I am Professor Dabiru Sridhar Patnaik, Director of the Center for Postgraduate Legal Studies and Executive Director of the Center for South Asian Legal Studies at the Jindal Global Law School of the OP Jindal Global University. Today, I will be engaging with you on the unit Human Rights and Duties, a Religious Perspective, on behalf of the content writer Mr. Nizamuddin Ahmed Siddiqui, currently working as Assistant Professor of Law at the West Bengal National University of Juridical Sciences. So, in this unit, the students will be able to understand the concept of religion as a basis of rights and duties. Also, it is important that you must be in a position to appreciate the similarities between religion and modern day international humanitarian law as well. Also, you must be able to understand the concept of human rights and duties from a religious perspective. The first part of this unit talks about understanding religion in international law. It has been the most challenging task for philosophers in this context to arrive at a common definition of religion that has been accepted by all. Commonly, as we understand, people relate religion with a belief or faith in a particular God. Sir Williams, a professor of Sanskrit at Oxford University, had once said that a religion in proper sense of the word must postulate the existence of one living and true God of infinite power, wisdom and love, the creator and preserver and designer of all things, visible and invisible. And it must take for granted the immortality of human soul. One of the broadest definitions of religion was given by Taylor, where he said that religion is a belief in spiritual beings. Now, religion can be defined in two ways. One, by the content of the teachings that religion spreads, and second, the manner in which the beliefs are held. While the former gives an abstract definition to the superpower, the later that I just mentioned, it indicates the methods of achieving oneness with the supreme power. Apart from our everyday encounters with religion, my dear friends, like in our morning prayers or a civic strife in the city, religious codes like say the Islamic Sharia, the Jewish Halakha and Hindu law have codified such norms which it believes to govern the perfect life of all human beings and governing their rights and duties as well at the same time. So, we need to understand that such norms that tend to bring us near to a perfect human life always have an emphasis on duties than on rights of individuals. And these duties that emanate from religion have been based on the moral grounds that religions lay down to guard relationship among communities. we need to understand, to ensure that these duties are enforced, religions have also introduced punishment that have the sanction of God to instill fear among people, according to one school of thought. And this fear led to the development of social norms having the force of law in early human civilization. And throughout this module, we will see how religion contributed to the concept of human rights and duties. Moving on, let us also now understand the religious basis of what we are discussing about rights and duties. We all know that it cannot be denied that some important legal principles have found their origin in religion. Say, for example, consider the word sin in religion developed into the concept of criminal offense in law. The 7 commandments of the church, one of which says, you shall not kill, you shall not steal, overlap with the normative law. In place of punishments, for instance, Christianity has the concept of canons. Although priests claim that canons cannot be synonymous to punishments, yet the origin of punishment can be traced from there. Another important point, other religions also have similar concepts of improving and easing the soul. Apart from the concept of crime and punishment, some rights also had their emanation from religion. Consider, for example, the Islam's inheritance rights. They have been among the first ones to recognize women's share in inheritance. So, the concept of rights and duties in contemporary period could be traced to the religious teachings. And it's important to know this chronology and historical facts. And it can be said that morality forms the basis of religion, and religion and morality go together, forming the basis of law. We will attempt to try and understand these contributions one by one. Let us start with the Judeo-Christian tradition. Now, according to this tradition, the central idea of beliefs of Judeo-Christian tradition is that God is the creator of all things. This supports the idea of rights that all enjoy by their common humanity. Therefore, the human being, as we all know, has the absolute and inviolable worth. Now, consider the Christian understanding of human rights is also centered on the belief that human life is entirely a function of the value divinely granted to humans through Christ. Now, it negates the presence of any social difference and imposes the idea of universal equality, which is again one of the bases for the modern international human rights principle. The fact that the Judeo-Christian tradition recognizes the idea of the creation of man in the image of God, it also strengthens the principle of absolute freedom and grace, which are again the universal principles of human rights. Now, as an example, the idea of inherent rights and dignity as explained in religious terms can be seen to have implications on the debates and the law of euthanasia as well. As a sampler, the European Court of Human Rights states that the right to life under Article 2 of the European Convention of Human Rights, it does not include the right to die, because Christianity condemns suicide and regards itself as a self-murder. However, this does not mean that religion can provide for a theory of human rights in all aspects. For example, the Bible, it claims that all have dignity, including the fetus. The law, however, has not recognized so. The fact that this biblical viewpoint is not represented in law means that all aspects of human rights can be explained or may be explained by a biblical or any other kind of a religious theory. If in case we talk about the religion which is known for its spirituality, Hinduism also comes to our mind, and it has also been the basis of several rights and duties. Now consider, Hinduism, like Judaism, has no word for rights. The closest word to rights is adhikara. Adhikara, which relates to the idea of what is a just claim. However, adhikara or just claim can be claimed only when a complementary duty is performed. And in Sanskrit, this understanding relates to the central concept of dharma, which is the central doctrine of Hindu thought and philosophy. The word which finds its roots and which is meaning to uphold, sustain and nourish. And this comprehensive term encompasses the meaning of duty, morality, law, order and justice. For example, it can be used in a ritualistic context to mean the religious duties, or it can be used even to mean the duties of different castes or varna dharma, or it can even refer to those duties that are common to all irrespective of class. Different perceptions. In the Mahabharata, a Hindu religious text, it has been written down that if the king does not perform his rights, then the subjects can overthrow him. And this is a prominent example that explains the concept of rights in a reverse manner. That is, the fact that not fulfilling the duties gives a right to rebel itself establishes the existence of a right. And through this example, friends, human rights can be interpreted in the context of human duties. Therefore, Hindu thought places Article 29 of the UDHR prior to any other article. The father of the nation, Mahatma Gandhi, once expressed that all rights to be deserved and preserved came from duty well done. Thus, the very right to live accrues to us not only when we do the duty of citizenship of the world. Now, let's consider the other important component, Islam. Islam is a religion which has its rights and obligations expressly written. It provides an amalgamation of rights and obligations in an express form that focuses on social responsibility. The principle of Islam incorporates that every person shall be equal and without being marginalized shall be included as a part of the whole. Like the key terms used by the Quran and the Sunnah in this regard are Haq Allah and Haq Allah Ibad, meaning the rights due towards the Creator and the Sustainer and the rights of Allah's servants, that is human beings. While the Western idea of rights is conferred by the crown or barons, Islam focuses on the idea that rights are not conferred by some authority but is a matter of one's own fulfillment. It shuns the idea of class struggle, thereby bringing human rights in its purview in a subtle manner. Now, these rights are not determined in view of the social status or the politics of majority and the politics of minority, nor are they linked to any racial or gender considerations. The Quran and the Sunnah declare all human beings as progeny of Adam. Therefore, all humans, irrespective of their gender and color, are declared essentially equal. Islam identifies with 7 principles of universal ethics and recognizes them for the whole humanity. And now they are not exclusive to Islam. The universal Islamic call for the unity of mankind is also based on these non-variables. The rights and obligations of an individual help in the social construction of reality on the important principles of justice and equity. Now, man's social interaction and the evolution of society and culture are directly linked in an evolving manner with those 2 principles. And these principle-based values are meant to be translated in the day-to-day socio-political, economic, cultural, and even international behavior and rights of man, of course. And this philosophy identifies the principles of human rights that are embedded in Islamic and other religious doctrines. Now, over the years, the concept of rights and duties have emerged, and it is therefore important to understand how this transition took place from religion-based rights and duties to modern international treaties or conventions. Some historical facts. For 1000 years, philosophy in Europe had been dominated by medieval Christian theologians since about the 12th century by a tradition called the scholastic tradition. First diversion from it was the Magna Carta that was issued in 1250. And beginning at around 1400 in Italy, Europe experienced a dramatic intellectual movement called the Renaissance. And Renaissance emphasized the resurgence of science and culture through classical influences. And what does Renaissance mean? The term Renaissance literally means rebirth. and was first used in the 19th century to refer to this extraordinary period. It set a new direction for art, architecture, music, literature, scientific discovery, and world exploration. And philosophy was also a beneficiary to this period of renewal. In philosophy, the stage that follows on the heels of Renaissance is called the modern period. And for Grotius, natural law is a rational principle of morality and social justice, which cannot be changed even by God Himself. In fact, he goes so far as to say that natural law would still have some validity even if we conceded that there is no God. In this way, natural law is considered a secular phenomenon, not just a divinely created one. And reason itself, he argues, contains a clear standard of moral rightness, and certain actions are unquestionably evil when compared with the nature of a reasonable being. And according to Grotius, there is a highest moral principle of natural law which is embedded in our rational nature, namely that we should be sociable. We should live in peace with one another and uphold the social order. Talking of these developments, a second great contributor to a new conception of morality and natural law was Thomas Hobbes, who took a more skeptical approach to the subject of religious basis for rights and duties than Hugo Grotius. And the backdrop of Hobbes' political philosophy is his materialist view of the physical world and the human nature. The standard view of the subject since the Middle Ages was the dualist position that the universe contains both material things like, say, rocks, and non-physical spirits such as God, human souls. Hobbes denied this view, holding that the universe is comprised entirely of material stuff. And in this process, he developed the concept of contract theory that gave rights and obligations to people. And according to him, the state of nature is a miserable, immoral condition that we should escape from if we hope to have a long and happy life. But how can we do that? For this, the solution for Hobbes is to devise an agreement with others that we together form a social contract by which we agree to set aside our hostilities, thus to create a peaceful society in which we can have long and even fruitful lives. And in his words, whatever therefore is consequent to a time of war, where every man is enemy to every man, the same is consequent to the time wherein men live without other security than what their own strength and their own invention shall furnish them with. In such condition, there is no place for industry, because the fruit thereof is uncertain, and consequently no culture of the earth, no navigation, nor use of the commodities that may be imported by sea, no buildings, no instruments of moving and removing such things that requires much force, no knowledge of the face of the earth, no account of time, no arts, no letters, no society, and which is worst of all, living with continual fear and danger of violent death, and the life of man solitary, poor, nasty, brutish and short. So, modern philosophers have justified the basis of human rights through high reason and not religion. So, the basis of religion in formation of rights and duties are not as strong now as it was during ancient times. One of the perspectives. And this could be seen in the development of international law as well. Modern international law, for instance, developed out of Renaissance Europe that we discussed a while ago, and is strongly entwined with the development of Western political organization at that time, and the development of European notions of sovereignty and nation states would necessitate the development of methods for interstate relations and standards of behavior. And obviously, these would lay the foundations of international law. However, while the origins of the modern system of international law can be traced back to the Treaty of Westphalia that brought an end to the Dutch-Spain War in 1648, the development of the concepts and practices that would underpin that system can be traced back to ancient historical politics and relationships thousands of years old. As international customs and trade became more important as the source of rights and duties, the role of religion started getting diminished. The Hanseatic League of more than 150 entities in what is now Germany or the Scandinavia and the Baltic states also developed many useful international customs which facilitated trade and communication, among other things. Also, the Italian city-states developed diplomatic rules as they began sending ambassadors to foreign capitals. Treaties, agreements between governments intended to be binding became even a useful tool to protect commerce. Earlier, the relation between states was largely based on canons of the Catholic Church. But the idea of detaching international relations based on religion was propounded by Hugo Grotius, who, as I just mentioned a while ago, believed that the natural law came from essentially a universal reason common to all men, unlike others who believed religion to be the basis of international law. So, human rights has its basis in religion, and it is important that we discuss religion's impact on human rights. Voices against intolerance and respect for religious human rights can also be traced back to even ancient times, because the basic feature of a religious human right is respect the religious beliefs of others. The ancient teachings of Hinduism, for example, denigration of beliefs of other religions are itself condemned. The religious texts not only condemn such an approach, but accept that tolerance towards religion would bring good to the society. Similarly, also consider Buddhism. Buddhism is rooted in the concept of religious freedom and respect for religious human rights. The ultimate ground for respect for all religions is also found in the Talmudic writings of Judaism. Now, Judaism teaches the infinite worth of every individual's life. In Christianity, the manner of God's dealing with human beings can be witness of the value given to rights of individuals. In Islam, Quran categorically mentions that there should be no compulsion in religion. The existence of God in every soul has been the teachings of Sikhism, which forms the basis of equality among individuals. Therefore, the basic human right of religion can be found in the teachings of every religion. Now consider this, coming from another thinker. 50 years after its proclamation, Michael Ignatieff writes, the Universal Declaration of Human Rights has become the sacred text of what Elie Wiesel had called a worldwide secular religion. The growth of human rights movement has given it the confidence to take on controversial issues and extend the promise of the Universal Declaration on Human Rights even in those areas that it had previously neglected. As we all know, religion indeed plays a pervasive role and often a powerful role in global affairs. Problems of a religious nature often even implicate international security as much as they do human rights. In a trend that was reminiscent of King Louis XV and the 1649 proclamation by Louis declaring that French protection of the Maronite community in Lebanon, or of the 19th century European powers, humanitarian interventions against the Ottoman Empire to protect persecuted Christians, religious freedom and the fate of religious minorities have assumed an increasingly prominent place in international relations and international diplomacy. Even in 1998, under pressure from Christian groups and representatives of a number of other faiths, the United States Congress passed the International Religious Freedom Act. The purpose of this particular law, through which it established an Office of International Religious Freedom in the State Department and an independent bipartisan commission on international religious freedom, and they were tasked with monitoring and reporting on the incidents of religious persecution around the world. And based on the annual reporting of these bodies, the United States President can take diplomatic and economic measures against countries of particular concern, making one's right to freedom of religion a unique yardstick of foreign relations. So, the religious human rights equation and its role in global politics are made still more complex due to major differences among democracies concerning the place of religion in public life. The gap between a post-religious Europe and the United States is particularly significant, and it's not without its own consequences for the priorities and approaches of the international human rights movement. For instance, in the 1970s and 1980s, religious and human rights groups shared many objectives reflecting a common conviction of the universality of the human rights message and its grounding in the traditions of most religions, philosophies, and civilizations. Religion-based traditionalism seemed on the wane, and culturalism and the black boxing of cultures as exclusivist identity and identity reference was not allowed to tyrannize human rights. And here, the conferences sponsored by the UNESCO in the early 1990s on the theme of inter-religious dialogue and the 1993 United Nations sponsored most important World Conference on Human Rights in Vienna and its recognition of the universal character of human rights were important high points of this convergence between the human rights movement and mainstream religious communities. Most in the secular human rights movement agreed that there was indeed a faith-based commitment to human rights. And this convergence was also helped by the priorities imposed on the human rights movement due to the brutality of some governmental repression. The conference organized by UNESCO on the contribution of religions to the culture of peace was held in Barcelona in December 1994. And civil and political rights were an immediate question of life and death, while issues more likely to separate rights and religious communities were confined to the sidelines. While most opted for a coexistence of differences on flashpoints like sexuality or abortion. In Mexico, for instance, the Bishop of the state of Chiapas, Samuel Ruiz, could join with secular human rights activists on civil and political rights issues. And even on social justice concerns implicating rights to health and housing, while retaining his more traditionalist positions on issues like sexuality and reproductive rights. The concept of religious freedom, as acknowledged in Article 9(1) of the European Convention on Human Rights, which says that everyone has the right to freedom of thought, conscience, and religion. And this right includes freedom to change his religion or belief, and freedom either alone or in community with others and in public or private to manifest his religion or belief in worship, teaching, practice and observance. There are inherent difficulties with protecting people's belief or beliefs, and that is because some people believe anything, and the law therefore must develop specific methodological tools to perhaps weed out those beliefs, in contrast to some religious beliefs which are regarded as rational, are not seen as worthy of protection at all. For instance, the House of Lords has recently stressed the importance of giving the benefit of the doubt to the claimant in this area to avoid the problem of subjective interpretation. In one of the cases, Christian parents who accepted certain biblical prescriptions concerning corporal punishment of children and challenging legislation banning the administration of corporal punishment in independent schools as a particular violation of Article 9 rights. And Lord Nicholas set out the requirements for a belief to come within Article 9. And the requirements are: the belief must not be trivial, and the belief must be consistent with basic standards of human dignity or integrity. And the belief must also be coherent in the sense of being intelligible, which means capable of being understood. But again, too much should not be demanded in this regard. Typically, religion involves belief in the supernatural. It is not always susceptible to lucid exposition or still less rational justification. The language used is often the language of allegory or symbol and a metaphor. And depending on the subject matter, individuals cannot always be expected to express themselves with cogency or precision. And this position is a clear reference to, and the relaxation of the other view, the Strasbourg view of what amounted to beliefs. And in one of the other cases, it was held that beliefs attain a certain level of cogency, seriousness, cohesion and importance, and beliefs does not have to be religious. The atheist, the agnostic and the skeptic are as much entitled to freedom to hold and manifest their beliefs as the theist. But for its manifestation to be protected by Article 9, a non-religious belief must relate to an aspect of human life or behavior of comparable importance to that normally found with religious beliefs. And it is not immediately obvious what might be included in this category at all. And some religious sanctions have been lately recognized to be of no legal basis. Consider this case. In Vishwalochan versus Union of India, it was held that fatwas issued by the Sharia courts with the intent of providing justice specifically to the Muslims who failed to get justice in the prevalent justice delivery system owing to the expensive and the protracted litigation, have no legal status and hence cannot be enforced by any process using coercive method. The existence of Sharia courts and the practice of issuing fatwas is not illegal, although it has no legal and constitutional scheme. An interpretation of religious texts is needed here. Also, certain basic rights have been adopted through legal precedents even when they conflict with religious principles. For example, the Supreme Court of India held that, I quote, persons of any faith can adopt a child under the Juvenile Justice Care and Protection of Children Act. And the act will prevail till uniform civil code is achieved. And the Muslim personal law will not stand in the way of such adoption, unquote. A bench led by Chief Justice Sadasivam observed on a petition filed by Shabnam Hashim. And as seen before, human rights that emerge from religion usually have a complementary duty attached to it. While talking about this, obligations have been divided into two categories by some organizations. Consider the European Court of Human Rights here. And these obligations can be negative obligations and positive obligations. The negative obligations require states not to interfere in the exercise of rights. The same is not true while talking about positive obligations. So, in human rights, people do have a right to non-interference in the rights that have been granted to them. However, these rights and obligations differ again from treaty to treaty, and they have been so fragmented to be laid down in different international instruments. But if you consider, the essence of these rights and obligations are universally the same. For example, the obligation of states in relation to economic, social and cultural rights are expressed differently from treaty to treaty. So, to conclude, we can say that even though states may realize economic, social and cultural rights progressively, it's important they also take action irrespective of the resources they have in some areas like elimination of discrimination, economic, social and cultural rights, and obligations or obligation to take steps and non-retrogressive measures and to fulfill minimum core obligations. Furthermore, in order to clarify the meaning of states' obligations, they are sometimes put under three headings: to respect, that is refrain from interfering with the enjoyment of the right; to protect, that is prevent others from interfering with the enjoyment of the right; and to fulfill, adopt appropriate measures towards the full realization of economic, social and cultural rights. So, with this, we come to an end of the discussion we had in this particular unit. Thank you very much.